Child support is a crucial part of raising a child. It helps provide for their basic needs. Sometimes, life circumstances change. When they do, a child support order might need to be adjusted. California law allows for child support modification. This means the amount someone pays can go up or down. Understanding how to modify child support is important for both parents. This guide will walk you through the process. We'll use simple language. It's important to remember that this is for informational purposes only. It's not legal advice. You should always consult with an attorney for advice specific to your situation. Child support orders aren't set in stone. They are designed to be flexible to accommodate the changing needs and circumstances of both the parents and the child. They can be changed if circumstances change. This ensures that the child support system remains fair and equitable for everyone involved. One common reason is a change in income. Financial situations can fluctuate due to various reasons, and it's important that child support reflects these changes. If one parent loses their job or gets a big raise, the child support order might need to be adjusted. This ensures that the financial responsibility is shared fairly. Another reason is a change in the child's needs. As children grow, their requirements evolve and so do their expenses. As children grow, their expenses increase. They might need new clothes, school supplies, or other essentials that weren't previously considered. They might need braces, tutoring, or participate in more extracurricular activities. These additional costs can add up quickly. These costs can be factored into child support. It's crucial to ensure that the child's needs are met without placing undue burden on either parent. A parent's ability to pay can also change. Financial stability can be affected by various factors, including health and employment status. Maybe a parent becomes disabled or has a new medical condition. These situations can significantly impact their financial capacity. This could make it difficult to keep up with the current child support payments. Life throws curveballs, and the system needs to adapt to these changes. Understanding when modification is necessary protects both parents and the well-being of the child. It's about ensuring that the child's best interests are always the priority. Before you can request a child support modification, you need to gather your financial documents. This includes proof of your income, expenses, and assets. Pay stubs, tax returns, and bank statements are all helpful documents. You'll also need information about the other parent's finances. This can be tricky, but it's important to present an accurate picture to the court. Organize your documents carefully. A clear presentation can make the process smoother. Remember, the goal is to demonstrate how the change in circumstances affects your ability to pay or receive child support. Section 4. Reaching an agreement outside of court. Going to court can be expensive and time-consuming. The legal fees, court costs, and the emotional toll can add up quickly, making the process overwhelming for many families. That's why it's often best to try to reach an agreement with the other parent outside of court. This approach can foster better communication and cooperation between both parties. Start by talking to the other parent about your situation. Open and honest communication is key to understanding each other's perspectives and finding common ground. Explain why you think the child support order needs to be modified. Provide clear reasons and any supporting documents that can help make your case. If you can come to an agreement, you can write it down and submit it to the court for approval. This written agreement ensures that both parties are on the same page and have a clear understanding of the terms. This is called a stipulation. A stipulation is a formal legal document that outlines the agreed-upon terms. It's a good idea to have an attorney review the stipulation before you submit it. An attorney can ensure that the agreement is fair and legally sound. Mediation is another option. A neutral third party can help you and the other parent reach an agreement. Mediators are trained to facilitate discussions and help resolve conflicts. Remember, cooperation can save time, money, and stress for everyone involved. Working together can create a more positive environment for your children and help maintain a healthy co-parenting relationship. Section 5. Filing for modification with the court. If you can't reach an agreement with the other parent, you'll need to file a petition for modification with the court. This is a formal request asking the court to change an existing order regarding child custody, visitation, or support. It's important to understand that this process can be complex and may require substantial documentation and evidence to support your request. You can find the necessary forms on the California Court's website. These forms are designed to help you outline the changes you are requesting and the reasons for those changes. Make sure to read the instructions carefully and fill out each section accurately. The forms can be confusing, so it's a good idea to seek help from an attorney or a legal aid organization. Legal professionals can provide valuable guidance and ensure that your paperwork is completed correctly, which can help avoid delays or rejections. Once you've filled out the forms, you'll need to file them with the court clerk and serve them to the other parent. Serving the documents means officially delivering them, usually through a process server or law enforcement officer, to ensure the other parent is notified of the modification request. The court will then schedule a hearing. This hearing is an opportunity for both parents to present their case and for the judge to ask questions and gather more information. At the hearing, the judge will review your case and make a decision. The judge will consider the evidence presented, the best interests of the child, and any relevant laws or guidelines. Be prepared to present your evidence and answer questions from the judge. This might include providing documents, witness testimony, or other relevant information that supports your request for modification. While it might seem daunting, remember that the court process is in place to ensure a fair outcome based on the best interest of the child. The goal is to create a stable and supportive environment for the child, reflecting any changes in circumstances that may have occurred since the original order was made.